Protocol Trigo County case number 22 CR 10, State of Kansas versus Ashley Wise. Announce appearances.
May it please the court, Your Honor. State appears by Trigo County Attorney Curtis Brown.
Your Honor, the defendant Ashley Wise is appearing in person via Zoom, and she's in custody, and by and through counsel Colton Eikenberry of Hayes via Zoom.
Ms. Wise, do you have any objection to us conducting this hearing by Zoom?
No, sir.
All right. And this is on the state's motion to revoke, correct?
That is correct, Your Honor.
All right. And so, Mr. Brown, you may, I guess, Mr. Eikenberry, does your client contest the allegations of the motion to revoke?
Your Honor, we have gone over the affidavit. There are 5 things listed in that. We are not requesting an evidentiary hearing regarding those allegations, and so we will not contest them.
Okay. Ms. Wise, let's go over those. It alleges that on December 8th of last year, you were arrested in Harvey County for suspicion of possession of a controlled substance. You were in a vehicle being driven by a Philip Austin, a known felon, when you were pulled over, and you're not allowed to associate with known felons while you're on probation. On that same date, in the center console of the vehicle that you were in was a Smith & Wesson handgun with 6 rounds of ammunition. At the time you were in Harvey County, you had not received permission to be out of county from your probation officer. And again, on that date, it was at 1:13 a.m. in the morning, and you had a 9 p.m. curfew, and you had not been given permission to be outside curfew. That's the allegations. Do you admit all of those things are true?
Yes, sir.
So, and you would stipulate they're violations of your probation?
Yes.
Okay. All right. So now we need to talk about court will find the defendants in violation of probation. We'll talk about disposition. Mr. Brown.
Your Honor, the court's well aware of the defendant. We started with this case back in September of 22, where she was placed on probation, which included participation in recovery court. We had our first motion to revoke filed almost a month later for positive UAs for methamphetamine. Ms. Wise was sent to inpatient at CKF. She was discharged unsuccessfully, sent to a second inpatient treatment at City on the Hill. She was able to complete that successfully. The state withdrew their motion at that time. Then a second motion to revoke was filed in February. Again, positives for methamphetamine, was sent to a third inpatient facility at Kissa. This time she completed that and was allowed to work her own recovery plan back in Plainville. That was her request. And she was out of recovery court at that point. And then now we have a third motion to revoke. Again, she's out of county. She's out of past curfew. She's with a felon. There's methamphetamine again in the car. There's weapons in the car. The state believes that we're out of options. We've done every single thing we could. Corrections has done, put her in all the programs that they have. We've done 3 inpatient treatments. We've done recovery court. We've allowed her to work her own plan, and we continue to have involvement with methamphetamine. Ms. Wise has put a value on her addiction that's higher than her value of freedom. And so I don't think there's any other choice but to revoke Ms. Wise's probation and have her serve the remaining of her underlying sentence. I've got 277 days credit, which is a little over 9 months on a 20-month sentence. I think there's a public safety concern with her continued involvement with methamphetamine. There's also, it puts herself in danger with her continued involvement with methamphetamine. I think the state's left at no other option but to request that she serve her remaining underlying sentence.
Yeah, Mr. Eichenberg.
Thank you, Your Honor. We were last in front of you, I believe it was in July, and Ms. Wise was put back on probation at that time and given another opportunity. Since that time, this batch of violations essentially happened because she will tell you she made the bad decision to get in a vehicle with Philip Austin. She does not believe that she is going to be charged with any offense arising out of this. I do not believe that she has tested positive for any substance that is prohibited on her probation since we were last in front of you in July. So essentially what she's done is make a bad decision to get in with Philip Austin, go to Wichita, and she'll tell you she was doing that to go shopping for her kids for Christmas. I don't know that probation continuing on is something that she even wants to have happen at this time after several stints in jail, but she has made progress since we were here last. I think maybe an appropriate solution might be to simply terminate her probation unsuccessfully. The court does not want to do that and feels like that would be a reward for her for making this particular bad decision. Maybe the court would consider reducing her underlying sentence, giving her credit for the in excess of 9 months that she's already spent in custody during the pendency of this case. She just has a 20-month sentence, I believe, and she's done over 9 already. So with that, Your Honor, I would ask that Ms. Wise be able to address you during allocution.
Okay. Ms. Wise, it's as Mr. Eikenberry knows, and I think you've been aware from appearing in front of me before, I always give the defendant an opportunity, if they wish, to address the court. And I'm going to give you that. Now, I want to mention one thing. Mr. Eikenberry said something to the effect that you were going Christmas shopping for your kids. I might point out that you were picked up at 1:13 in the morning in a vehicle. I am hard pressed to believe there was any establishment selling kids Christmas presents open at 1:13 in the morning, but nonetheless, you're welcome to address the court.
Well, of course, we didn't leave at 1:13 in the morning. Wichita is a ways away. My tags are out on my vehicle. I drive a fairly newer vehicle, so my tags are $400. I didn't have the money to do Christmas and get my vehicle tags. So I took a ride and I was trying to go get some Christmas gifts. And of course, as things go, when you're at the mercy of somebody else in their vehicle, things happen. And unfortunately, I planned on being back before my curfew, but it just didn't happen that way. Since seeing you last in July, I have not failed one UA. I was in a cognitive thinking class, which was really helping me, which obviously I needed because I made a stupid decision while sober. And I was actually going through Kansas Works and Great Bend to get my, they were going to pay for my reinstatement for my nursing license, my refresher course. I just needed to find a place that would allow me to take my clinicals there and agreed to give me a job. So I was just about to get my nursing license back. I was taking a cognitive thinking class. I did not fail any UAs. I was doing everything that I needed to do. I had my kids full time. I have an apartment. I mean, I was doing everything that I needed to do, and I was sober. That cognitive thinking class centers around trauma and healing that trauma and figuring out why we make the decisions that we make. I feel like I have made a lot of progress since seeing you last. And I would also like to point out that the system has made me feel like it doesn't matter, like I don't matter. When I was arrested the last time, I passed my UA and they arrested me anyways because of what they think happened. I was kicked off the drug court for alleged criminal activity. And when Erin gave me my UA this time, she said, negative, since when? And when I didn't answer her quick enough, she said, oh, well, it doesn't matter anyway. And then the last time at court, I believe you told me yourself that you didn't think that I would make it anyway. So when I feel like I'm being set up or expected to fail, I was also not given any due process this whole time on corrections. I have never received one sanction, not one quick dip. Everyone else that I see gets 24 hours in jail or 3 days sanction or quick dip or whatever it's called, or 30 days. I've never had one of those. They have tried to revoke me 5 times. Anytime I get in trouble, they automatically arrest me. They throw me in jail for 2 months, 2 or 3 months, so I lose my job, I lose my apartment, I might have to be without my kids that long, and they do that to me every time. And then when I go to court again, they want to argue if I have a place to go. Well, fortunately for me, this last time I did, because my house was sitting there abandoned, but every other time they know good and well that I didn't, because they just threw me in jail for 2 months and I lost everything that I just worked so hard to build up. So I feel like that due process is not there for me. I feel like I get treated different than everyone else. And I feel like they feel like that I don't matter. And I do. I matter to my kids and to my family and the people that love me. And I was doing really well. I made a bad decision. And I don't believe that should overshadow all of the good that I have been doing.
Okay, anything else?
No, sir.
Okay, anything further from either counsel?
No, Your Honor.
No, Your Honor.
Ms. Wise, the court taking into account, I've reviewed your file. I looked at your pre-sentence investigative report. I took a look at the journal entry of judgment. You've reminded me of a variety of things. Regarding your experience with the court system, you're right. It's all community corrections' fault. You made one bad decision, but really they're the guilty party here. And the last thing I want to do is put you back under the control of the people that are causing you so much problems. So I'm going to reward you. I'm going to revoke your probation. I'm going to send you to prison so that you don't have to deal with community corrections anymore. Now, you will, when you get out, for post-release supervision, but that's a little different program than community corrections. And that way you won't be victimized anymore by community corrections. Okay? So probation is revoked. You'll serve the balance of your sentence. And is there anything further, Mr. Brown?
No, Your Honor.
Mr. Eikenberry.
No, Your Honor.
All right. Ms. Wise, you'd have the right to appeal if you believe that the revocation of probation is illegal or improper in any way. You must file that within the next 14 days. If you have any questions about that, you can direct those to Mr. Eikenberry. And with that, we will be adjourned.